Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is 01-24-00310 Tusker Capital Fund LLC versus Southside Development Project LLC. Starting with the appellant, counsel, can you please make your announcement?
Good afternoon, Michael Keller for the appellant, Tusker Capital Fund LLC.
Very well, and for the appellee?
Mark Courtois here for Southside Development Project LLC.
And tell me how to pronounce your last name, Mr. Courtois?
Courtois.
Courtois. Thank you very much.
Thank you.
Each side will have 20 minutes for argument. Mr. Keller, how long do you want to reserve for rebuttal?
5 minutes.
Okay, 5 minutes will be reserved for the appellant. And just before we begin, simple housekeeping matters. The clock is in front of you. When the light turns yellow, that means you have 1 minute left in your argument. Of course, if the light turns red, that means stop. Please feel free to finish your answer if you're in the middle of answering a question. The briefing in this case was excellent. We really appreciate it. It really helped us, the letters as well, guide us through the issues here. We really appreciate the parties' time and effort in helping us guide through the issues. We have reviewed the letters and the record. We are familiar with the facts. So if you guys just want to dive right into the legal issues, that would be most helpful to us. Starting with Mr. Keller, we're ready.
May it please the court. Your Honors, this case asks whether a lis pendens based solely on a constructive trust or an unjust enrichment claim can ever be valid under the Texas Property Code section 12.007a. The Texas Supreme Court case of Flores v. Haberman answers this question decisively: no. If the claim is collateral, if it is meant to secure a debt or to enforce an agreement, then it simply does not support a lis pendens claim. So, again, Your Honors, the Texas Supreme Court case of Flores is central to deciding the matter before the court today. In Flores, the Supreme Court held that a lis pendens is improper when the plaintiff seeks a constructive trust only to satisfy a monetary judgment. Now, the Supreme Court explained in that case that a claim that seeks to convert a monetary or a contractual claim into a real property-based claim through equity, like the use of a constructive trust, like what we have here, makes the lis pendens void. And that's, again, Your Honors, precisely what Southside has done in this case.
What's your best case for that? You pick.
Our best case, Your Honor, in what sense? In the lis pendens?
To invalidate the lis pendens.
The best case to invalidate the lis pendens is based off of Flores, Your Honor. Again, this idea that it has to be a direct claim in real property.
Mr. Keller, can I ask you as a follow-up to that question?
Yes, sure.
Flores was a mandamus application, and most of the cases that have been cited are mandamus cases stemming from the trial court's decision to either validate or invalidate a lis pendens. This procedure is a little bit different in that the lis pendens was not challenged directly. How are we now able to then evaluate whether the lis pendens was valid in this case, given that it was never challenged below in the 295th lawsuit?
So there's nothing, Your Honor, that requires that a party challenge the invalidity of a lis pendens through the motion to expunge the lis pendens under the statute. Certainly that is a permissible method to attack the validity of the lis pendens, but a void lis pendens is always subject to attack.
Do you have any?
Yeah, what's your best case for that?
It would be the voidness of the claim itself.
Okay, in an analogous context, right? Can you help us just understand, because if you're in a different proceeding, then they're people who are parties to the original proceeding or entities that are not parties to this proceeding. So can you point us to any analogous law or principles or something as to why this is a proper avenue to declare the lis pendens void?
I would just simply, again, point the court back to the general principle that something that is void ab initio is void. And it is always going to be subject to attack because the fact that it is void ab initio.
Okay, let me ask you again a related question.
Yes.
When the trial court judge entered judgment in the 295th action, that judgment says it supersedes the lis pendens. So in essence, the lis pendens goes poof, now you have a judgment. That judgment itself, of course, was not challenged. And so are we really looking at a lis pendens, or is the actual true thing that we're looking at here is the judgment that was entered, which in effect superseded the lis pendens?
The judgment in that case is what Southside attempts to bind with the lis pendens. Southside points to the lis pendens to bind Tusker Capital to that judgment. And so without the lis pendens, there can be no binding of the enforceable effect of that judgment as against Tusker Capital.
Well, they didn't have to follow lis pendens, right? If Southside decided not to follow lis pendens, they could have just followed the lawsuit, followed the agreed judgment, and gotten the judgment.
That's true. And in that case, similar to what we have here, that would have been subject to a collateral attack. As is true in this case, when something is void, because at that point, if we're talking about adjudicating title to the property, Tusker Capital would have been a necessary party to that lawsuit.
Right,
and
but you guys did not, your party did not institute a collateral attack. You filed a separate lawsuit that dealt with the superiority of the judgment and the lien, and then you appealed that. There has been no collateral attack on the judgment that was entered by the 295th.
So that's technically correct, Your Honor. There has not been a direct collateral attack, but what we did file was a question based, again, as Your Honor has pointed out, on the superiority of the liens as it relates to the binding effect of the lis pendens. Throughout the entirety of the case, Southside has contended that it is necessary for the lis pendens. The lis pendens is what gives effect, the binding effect to the judgment, and without it, it is not able to bind Tusker Capital to the outcome in that litigation.
So I have a question about that. You're the plaintiff here, right?
Correct.
In this lawsuit. So can you help me with housekeeping to organize what, you have 5 issues here, and I'm trying to just see how they all relate to each other. If we go this way, what happens to that one, and what relief are you seeking, and for both sides? I'll have the same question for you, Mr. Courtois. So walk me through what issues have to be reached in your world. What do you think we have to do? For example, on issue 1, if we rule against you, is the case over? If we rule for you, is the case over? And if so, on both, why?
So if the court rules in favor of Tusker on issue 1, then that is the end of the case. If there is no binding lis pendens, if the lis pendens was void ab initio, then that is the end of the analysis, because at that point we would ask that the court reverse and render.
Right, you asked, and I got that. I didn't really see much pushback, and we can have a conversation about this, but I want to figure out why is that necessarily true? What do we do with constructive trust and some of these other issues? Because they're not things we get every day, and so I want to make sure I understand it fully.
Sure. Again, with the potential void nature of the lis pendens, if the lis pendens from the underlying litigation is in fact void ab initio, as Tusker Capital contends, and this court so finds, then at that point there is no binding effect of the underlying judgment, which, by the way, was an agreed judgment, which is another issue that we've raised.
So you're saying if you were to win that first issue, then you don't really care what happens to the judgment in the 295th, and you're done.
That's correct, Your Honor.
Okay.
Is
now,
that because of timing? Maybe I'm not following you. Why is that? I understand the argument, I'm just not following you. If the lis pendens is invalid, if we agree with you, the lis pendens was void ab initio, there's no lis pendens, there's still an agreed judgment imposing a constructive trust over the property. That was entered after you secured your interest. So is that your point, that it doesn't matter because that interest would then come later? Don't we still have to determine whether the constructive trust as entered by the court was valid or not? And I think that's what Judge Gunn was getting at. So maybe that's the confusion, that we're not following the logic of lis pendens is gone, meaning we don't reach the rest of the issues.
I understand. So what I would say on that point is, once the lis pendens is gone, what Southside is left with is they are left with an agreed judgment that gave them arguably a constructive trust in the underlying property. But they will have no enforcement mechanism because in this case in particular, they were seeking to enforce the constructive trust by virtue of a foreclosure of the constructive trust, which the law does not allow for. The opposing party seems to conflate a constructive trust with an equitable lien, but the two are not the same. An equitable lien, as the name implies, does give the party that obtains the equitable lien a lien interest in the property, whereas a constructive trust is not a cause of action in and of itself, but is merely a mechanism in order to allow a party to, under the right circumstances, to ask the court for equitable relief because of unjust enrichment, in order to avoid unjust enrichment. And so really, Tusker's position is that the agreed judgment that was obtained in the other litigation that provided for constructive trust is really a non-issue, because there is no way for Southside to do anything with the agreed judgment for a constructive trust on that property. And at that point, if the binding effect of the lis pendens is done away with because this court decides that it's void ab initio, then we are back to where we left off, which is Tusker Capital has a lien interest in this property, and it can proceed with the foreclosure of that lien.
Help me understand this line between direct and collateral interest. So I understand Flores and I understand your position, but looking at the language, establish an interest in real property, how is that line really drawn as applied here? Meaning, if you have a suit, is your position, if you have a suit to get something that's similar to a mortgage, a suit to get an interest in property that's always removed in collateral, you have to be actually trying to enforce an existing interest in the property to qualify?
Not necessarily, no, I don't think that's the case, Your Honor. The difference between the direct and collateral, I think, to somewhat the back and forth in the case law is a bit of an overcomplication of the principle, really. I think it's spelled out fairly clearly in the statute. The statute says that a lis pendens is proper in three circumstances. There can be a title claim, there can be an interest in real property, or there can be an encumbrance on that property. One of those things, three things, has to be true. And here, that simply none of those are present. There was, originally a breach of contract claim for specific performance, which was none of those things. And then subsequently, there was a constructive trust claim, which is another issue that we have about whether we're even getting to the constructive trust because of the pleading issue.
But the breach of contract specific performance claim seeks as a remedy an interest in the property.
It seeks as a remedy an interest in the property, but that's precisely what the Supreme Court in Flores said is not permissible, that we can't have something that is an end workaround to get to a real property claim. It has to be a direct interest in the property. It cannot be collateral.
What would be an example of that? Because there's three categories, as the Supreme Court elaborated in Flores. And one of those, which I think what Justice Caughey was referencing, it says that there has to be a claim to establish an interest in real property, like a claim related to the establishment of an interest in real property. That suggests to me that the claim is to establish a right not yet existing in real property. So what would be an example of a claim that would fall within those parameters?
Right, within 2 rather than 3.
Right.
If that makes sense.
Right, that does make sense. And I don't believe that there's anything that's spelled out in the case law. In fact, a number of the cases suggest that the question of what is an interest is open-ended. But there are a number of different things that are identified in our briefing which state, what an interest might be, which again, in this case is not some future interest that might come by virtue of contract.
Well, why would it claim, the claim here is the agreement between Southside and Bella Trust, right, was that there would be a deed of trust that would be granted. Why is a claim filed to enforce that agreement for a deed of trust, not a claim for the establishment of a right to property?
So,
The establishment of an interest, right?
Right.
An interest in property.
right. Because it sounds in contract, right? They did not yet have a deed of trust.
Right.
It would be different had they already obtained that deed of trust, but they didn't have it.
So if
One
they
step
had-
removed.
Yeah, that's where I was going to
One
begin.
step
So if they
removed.
had the deed of trust, so that was my example, if you're trying to get an interest, you're saying it's not good enough under Flores, but if you already have the interest,
Yes.
then it is, so what would happen if you had a deed of trust, but you hadn't filed a lawsuit to actually,
To foreclose.
to foreclose, to do something with your interest?
Well, you would still have the deed of trust, Your Honor. I mean, the deed of trust would be in existence. You would have that title right.
So
You would
in-
have that interest right at that point, even if you hadn't yet filed litigation, perhaps, to foreclose on that. But one thing, I see my time is running short, and I'd like to just make this final point. The appellee has mentioned that this court has consistently held that pleading requesting the restoration of prior ownership interest is what gives rise to a valid lis pendens. And I think that's so important. That highlights this direct interest. And the case law talks about this again and again and again. It's the restoration, right, of that prior interest, which again, Your Honors, is the difference between what we have here with a non-existent deed of trust interest that should have been attained but was not yet obtained by virtue of contract, and something that was already in existence that they are now filing a lis pendens to alert the world that they are going to seek judicial relief in order to establish that interest through the court process.
So just to make sure I understand, if they had already gotten the deed of trust, then your position is the lis pendens would have been valid.
Correct.
The issue is just that they didn't have it yet. They were suing to try to get it, but they didn't have it.
That's correct.
Okay, thank you.
Any further questions? Thank you.
Not yet, but don't leave.
I will not.
We're not
I
done
will
with
be
either.
here.
We're not done with either of you.
Thank you, Mr.
Thank you very much.
Mr. Pourpois?
May it please the court. As an initial comment, I will say this case is more than just claims of unjust enrichment and constructive trust. We sued for specific performance. There was nothing else we could do. We had a joint venture with a partner, and we were buying properties, investing in the properties, and fixing them up. That's what it comes down to. And then the partners decided to split and go their ways. So a settlement agreement was reached. And in that settlement agreement, there's a discussion of the properties and what's going to happen with the properties. There was already a mortgage on this property, a deed of trust.
Held by whom?
Huh?
Held by whom?
First Equity, it was another party.
Another party.
But
Another
you
party.
didn't have a deed of trust.
We did not have a deed of trust.
So what do you make of the opposing side's point that if you had had the deed of trust, then you'd be in a different position?
That's not what the statute says. The statute 12.007 talks about 3 different types of interest: title, encumbrance, or establishment of an interest in real property. That's what this case is about. That's why we sued them for specific performance. We wanted the deed of trust. I don't know what else we could have done.
Why
And-
doesn't Flores pose a problem for you, though?
Flores is not a problem for us.
Can you help me understand why?
Okay, Flores is a case where the property was not part of the transaction. Okay, I mean, that's kind of what I was looking at when I was trying to give you a table of cases to look at, does the property, is that really what the property that we're talking about, is that part of the transaction? Is that part of the lawsuit? What are you suing me for? Are you suing me for this property, or are you suing me for a breach of contract and you're trying to attach some other property? That's what it's about.
But you're suing for breach of contract, and you're trying to get as a remedy an interest in the property.
I was trying to get a remedy in this property, this very specific property. This property was identified in our original petition and our first amended petition. And the only reason we added a constructive trust is that we learned later on that this guy had gone out and borrowed more against the property. Thank God we had put a Liz pendants on file. I don't know what else we could have done.
What would you specific, I agree, the party settled, but if you would have prevailed on your specific performance claim, what would that remedy have looked like? What was the specific relief that you were seeking under your specific performance claim?
He would have given me a deed of trust.
At that time? Yeah.
Right when I sued him. We had no idea that he had gone and done this other deal. That's in our petition. He had made noise to us and said, I'm going to go put another note on this property. That's why we sued him when we did, to stop anything going on at that point.
What's your best case for a situation like this, where you are a step removed, you don't yet have the interest in property, but your remedy would include an interest in the specific property?
So
what's your best case on that?
Well, there's a number of specific performance cases, if that's what you're asking. And
whatever you think is the most on point for you.
Okay. Well, Enray Musa from your court is a specific performance case. Gandhi versus Gandhi. Corpus Christi Court, 2011. Enray Cook from Beaumont. Enray Gaudet from El Paso. All of those are specific performance cases. And they looked at it, and all of the courts recognized that specific performance was a claim that could give rise to a potential Liz pendants. Now, in some of those cases, they looked at it and they said, there is no contract. But then we get into this whole issue about 12.0071 with the burdens and how a Liz pendants is supposed to be dealt with after 2009. That's not what they did in this case. And the courts have been pretty clear about looking at that. And there's a very specific statute about, if you want to cancel Liz pendants, you better get in that case.
So I'd love for you to talk with us a little bit about that.
I mean, all of the cases, and we cited several in our brief, but all of the cases are cases where people have intervened. If they're not already a party, they intervened because they understood that you stand in the shoes of that person, of that defendant, meaning that you take subject to the litigation. That's long-standing law. We've cited that. And that's really what they're trying to avoid. And that's why they did what they did.
I guess let me ask you this directly. In a hypothetical situation, if we were to think that the Liz pendants was void, would it be proper for us to be addressing it in this case anyway, yes or no, and
no,
why?
It wouldn't be I don't know how this court, there's nothing wrong with this court, but how this court looks at a different case and tries to set aside a judgment in a Liz pendants. The Liz pendants was never canceled, never expunged, and we're talking 2023, so what, 14 years since the statute was in place? I mean, we expected them, if they were going to come into the case. And they knew about it. They knew about the case. It's mentioned in their petition. And they got a copy of our agreed judgment. That's in the record. If you look at I can give you a cite to it, but in our record, the agreed judgment that was filed in that case, their law firm was on that service.
Mr. Keller to argue that because the Liz pendants, in effect, was void ab initio, he stands in the shoes of other parties who can always challenge a void judgment at any time, collaterally or otherwise. Why do you disagree with that in this case?
Okay, so if he really thought that, then the way to do that is do an equitable bill of review into that other case. Okay, an equitable bill of review. There's a couple of grounds for equitable bills of review. I didn't brief it, but that I've got it going on in another case, and what that really involves is you can do that years.
I thought you only had 4 years usually for bill of review.
Okay, so under the statute, you've got 4 years. But an equitable bill of review can go as long as possible on certain issues. One is extrinsic fraud, and the other one is due process. If there's constitutional due process issues, you can try to set aside a judgment long after.
But what if it's void but not a due process problem?
Well, again, he's still within the statute, I guess. You know, he can try and come in and assert some arguments that, you know, hey, this, you know, I should get a new trial on this. I'm not sure he can withstand that burden at this point, right? So I think but he's still within that, 2025? I mean, he's still within that 4-year window.
So I have a question about that in light of your answer. The difference between the lis pendens and the judgment from the 295th. So help me understand how the decision tree works, depending which way we go with different forks in the road. I mean, appellant says this is really about issue 1, the lis pendens up or down, and if it's no good, then that's the end of the case, because he doesn't care about the judgment. So help me understand your view on that.
Well, I would argue that the judgment is the judgment.
Sure.
And how do you set that aside? How do you do anything with that?
Fair enough. And I think I heard him say he doesn't care about the judgment at that point. He just cares about the lis pendens.
Right.
Nobody has set aside the judgment. The judgment's on file.
Right.
Gives a constructive trust over the property. When we responded to this lawsuit, we said, hey, we've got a constructive trust. We want to foreclose on it. We want to trespass the tri-title. We want to know who's got the priority of liens. That's what issue is in this case. Since they decided not to come into the case, this case was sort of inevitable anyways. I would have either had to file suit to clear up the title, or they would have had to file suit to clear up title. I mean, it was inevitable. What they should have done, if they were challenging everything, is that they should have come into the lawsuit. They knew about it, they had an opportunity to do it, and they didn't do it.
What case or rules did they had to proceed that way?
They haven't cited anything.
But you're saying that that's what they had to do. That's the proper way to challenge it.
12.0071.
Okay. Okay, and then
Well,
Colin,
I'm sorry, but 12.071 allows for the procedure, Mr. Keller says it's not required.
I'm not sure that that's true. I mean, I don't see any case law out there since 2009 about trying to invalidate a lis pendens. There's none. There's no authority that says I can go outside of this statute and try and invalidate. And the reason I'm saying that is because it's not only just, I mean, there are certain burdens that the court has to look at and weigh the evidence of the claim. And the legislature came in and was very specific about that. So, I mean, if you go down that road, I guess this would be making new law that since that statute is in place, now we've got an ability to file a deck action and invalidate it and not have those burdens.
And I'm going to ask appellant that on rebuttal, if it's new law or if there is law on that.
I haven't been able to find any law on that.
So your position is essentially this is an end run around. The legislature
Around
has
the
said this
statute.
is how you have to go, and then this is, if we were to follow.
Absolutely. I mean, we looked at this case and we didn't think this was we didn't think the issues were complicated. We filed a case, we had an agreement for the property, we filed suit, we asked to get the darn deed of trust that we asked for, and then he goes out and he does something else. I'm talking about Bellaterra.
Right.
And then we have to deal with this case. But our lien is right, the lis pendens was right there.
But that's only true if it's valid.
No, it's there. It's never been expunged, never been canceled. So if this court invalidates that, that's making new law.
But what if we were to agree that it's, your interest is collateral and not direct under Flores?
Well, I don't agree that it's collateral, number one, because it is.
Because you're saying you're chasing this specific piece of land.
This
I get
specific,
that.
there were 2 pieces of land. One was Avenue E and the other one was Westview, and we sued over both of them.
But why does that change it from collateral to specific if the question is just how removed you are that you don't yet have the deed
All
of
right, well,
trust?
so some of the courts have looked at it, including this court, have looked at it like, is the property the subject matter of the lawsuit? Is that really what you're going after?
But haven't we also said, it's not just, is it the subject property, but are you seeking restoration of rights in that particular property?
That's one of the other avenues.
So you're saying that's separate from,
I-
so.
it is.
Because you can have the subject property, which would be the case, for example, you're talking about removing it one step from Flores, which was securing the right to property that was acquired, like a third property that was acquired through the funds of the original property.
That's exactly right. That whole table was there to kind of guide us with the vision of, is the property that's at issue, is that the subject matter of your lawsuit, or is it some unrelated property?
But we have to look at not just that, right? Is it the subject property? I agree with you, at least that, right? It has to be the subject property. But what is the claim that you're filing for that particular property? For example, yeah, and I get your argument, but if this had not been, for example, specific performance and had been just breach of the settlement agreement, even though it's the subject property, you would agree that in that case, we would not have a valid lis pendens?
No,
Okay, gotcha.
no.
No, you agree, or no, you don't agree?
I don't agree with the comment that we don't have a valid lis pendens.
Right.
But-
I don't know how else we would have secured.
Get a follow-up. I thought he had answered no to the other, okay. Okay.
Hopefully I was clear. I didn't agree with the assessment.
Right.
that-
Well, then
that our
why
lis-
not? Why, if you're just suing for breach of the settlement agreement involving the subject property, why does that put you within the parameters of the
We
lis pendens
did
statute?
sue for that.
But how would that give you either enforcement of an encumbrance or establishment of an interest in the property? Those
Well,
are the two that would be
I
relevant,
mean,
right?
if that's the, I mean, I
Those
look
are
at
the-
the breach of contract along with the specific performance. Because
Right,
you gotta have a breach of contract with
divorce the
specific.
specific performance, or divorcing the specific performance from it.
I suppose if we were just asking for money damages, you might be able to say that. But that's not what we were asking for. And it was the subject of the property. But we're not asking for money damages. Our goal has always been to get the property, to get our interest in the property, which is what we agreed to with this nut before.
But
okay?
isn't this kind of like Moss, where you're not seeking title to the property or an interest except as security for your recovery of damages? Tell me why that's yes or no.
Well, I don't, I've looked at so many cases, I don't specifically recall
Okay, I'm sorry.
laws.
Okay, forget Moss, just that sentence, you're not seeking title to the property or to establish an interest except as security for the recovery of damages.
It's
Is that
not-
correct?
It's not security for the recovery of damages. We were not getting a money award from him.
You wanted the actual interest in the
We
property?
wanted the deed of trust.
Okay, and he agrees that if you had the deed of trust and you were just seeking to foreclose, that there would be a valid lis pendens.
Well, there's no question that a deed of trust is an interest in property, right?
Right.
I mean, I think that's, and so is constructive trust. So I think all of those are interest in property. I don't know what else we could have done. I mean, that, you know, I've sued for,
Well, you could have gotten the actual deed of trust earlier.
he refused to give it to us. I mean, what do I do?
You sue for it. You're right. I mean,
I
I hear you.
can't do anything else to protect our interest in that property. And it's not like, I mean, he had already agreed to give it to us. He had already recognized our interest in that property.
I don't see how that makes your claim better than the other side's. If the people at Bellaterra are, you know, running fast and loose with both of you, I mean, I hear what you're saying, but they can say the same thing. I don't understand why you have a leg up just because the Bellaterra got overextended and made promises they couldn't keep.
Well, I got a leg up because I filed a lis pendens. And when I gave notice to Bellaterra, they went and signed a deed with them.
I get that, but that all hinges on whether the lis pendens is valid. and makes me think, okay, is this a collateral or direct interest, a la Moss and Chong in the 14th Court cases and Flores and Haber?
Those cases are Moss, Chong, all of those cases have to do with properties that were not part of the subject transaction, that were just to collect whatever the case was going. And that's what those cases say, is that it is just, these are, they kind of, Flores has kind of spawned these series of cases. Are you really looking to try and get an interest out of this property? Or are you just trying to collect your money damages?
Right.
And that's what Flores looked at, and that's what Chong looked at, and that's what Jackson looked at. All of those cases looked at that. But if you look at it through the lens of, which is kind of the, let's look at it, is it the subject matter of the lawsuit? The Beaumont Court of Appeal said, is there a nexus?
Okay, but come back to, let's say we're looking at it in the post-Flores world as, is this trying to get you your money, or is this an interest in property? Help us understand why you fall on the interest in property side.
I didn't ask for money damages.
Because of the specific performance aspect of your
Because of the specific performance. That's
because
exactly right.
what you're seeking is the actual, the deed of trust.
I was asking for the actual deed of trust. That's all I really wanted. And that's why we sued him for it. Hopefully he would have given it to us, but he never did. And that's why we're in the situation we're in right now.
Can you help me understand the difference between 2 and 3? Because 2 is to establish an interest in the property, and 3 is to enforce an encumbrance.
Right.
And if you already had the deed of trust and you were trying to foreclose, that would be enforcing an encumbrance, right?
Well,
so then what falls into category 2 then? Is it mostly a situation like what you're arguing is happening here?
I'm not sure I understand the question, but I do know that 2 and 3, the encumbrance is 3, and then establish an interest in property. That's clearly establishing an interest in property. I do think that there was an encumbrance in this case too, because he had already given us an interest, recognized an equitable interest in the property. That's what's stated in the settlement agreement. And so in our brief, we said, yeah, 3 is also applicable to us because we've got we've got an interest in that property.
Before you run out of time, you might have already answered this briefly. I just want to make sure I understand. Assuming that we could reach the issue of the validity of the lis pendens, and if we were to agree that the lis pendens was invalid, what is left? Would you still have a judgment? Would there be anything left to adjudicate at that problem? Like, will we have to then reach the issue of the constructive trust? Help us figure that out.
I wish I could. I've got a judgment in a separate case that's never been appealed.
Right. Never
been attacked. I've got a lis pendens that's never been appealed, never been attacked. And if this court comes in and says, oh, your lien, your lis pendens is void, I mean, that would be surprising, but if that's what would happen, I don't know what would happen to that judgment. It's still on record. It's still in the real property records. I suppose some litigation would have to go to say, I want to remove that because no title company is going to issue a title policy on things that are claiming conflicting things in the title. I mean, I think it depends on what the court does with, if it's void ab initio and you go, yeah, we're going to render judgment. And you
but
could,
how would we?
I don't think you can. I don't think you can. That's what I'm saying.
I'm not persuaded that we can't. I mean, we're having a conversation because the appellant's brief says stop there and render, and it's not clear to me why. And I don't know that we've all really joined issue on what happens then in that hypothetical world.
Well, there's a lot of tangential issues that could be raised on a simple lis pendens. These are not the sexiest of cases, obviously, and so they come up to the courts of appeals occasionally. They are important to protect people's rights and property interest, and so they're used fairly frequently.
But would the constructive trust be before us, the issues on the constructive trust, would those be before us? Or would that be something that you would go fight about in
I had another
below?
court give me a constructive trust
Right,
over the property.
right, and nobody's appealed that, in that
I
case.
don't know how you could address the merits of that order in this case.
No, you've got that judgment.
Right.
I have that
Right.
judgment.
I don't know that that's quite before us. We may hear otherwise, but I'm not seeing that.
Right. Any further questions? Thank you, Mr. Courtois. I
Thank you.
appreciate it.
Thank you.
Mr. Keller, when you're ready.
Your Honors, again, the appellee talks about whether this is a direct or a collateral interest, and we've touched on this. And they tried to frame it as if this is, in fact, a direct interest, as if this was the object of litigation. But again, this is merely a means of collecting the debt. The facts of the pleadings show us that. There was money that was given by Southside to Bellaterra in this joint venture, and that money ended up, supposedly, based on the allegations, in this property. They never had a deed of trust. They hoped to have had a deed of trust, but they never obtained that.
Help me understand very quickly on this prong 2 versus 3. The enforcement of an encumbrance, if they had the deed of trust, would presumably fall under 3. So what falls under 2 then? What is the establishment of an interest?
I think that's a question that has perhaps not been answered by any court previously in a case like this. But it's certainly the case law tells us that this is not it.
Okay.
Because this is not the restoration of a prior interest. And like the cases that...
Mr. Courtois says the restoration cases is a question apart from establishment of a property right. Do you agree with that?
No, Your Honor. I mean, none of the cases that are before the court address anything like that, even make an argument like that. And in fact, many of them talk about situations which are very analogous to what we have here, where funds that were, for one reason or another, were misappropriated, and they ended up in real property.
In the post-2009 world, are there examples of list pendants being invalidated apart from the statute? We heard an argument about new law, so I want to give you a chance to respond to that.
I don't know, Your Honor, that there's any specific case law that talks about the invalidation of a lis pendens outside of the statute.
How is this not a problem, as Mr. Courtois described, of you kind of getting to avoid, the legislature said this is how you invalidate a lis pendens. How is that not a problem for you to then just not have to do that?
Well, typically, I would say the first thing is, typically when you're talking about expunging a lis pendens, oftentimes that's done, again, within the context of a party that's actually a party to the litigation.
Well, most of the cases that have been cited in your brief, though, some include an intervener who can intervene to invalidate the lis pendens or challenge.
Absolutely, that's true. And part of, just in total candor with the court, part of what happened here was just a timing issue. So this goes back to the original suit was brought by Southside in August 17th, 2022. And then there was this settlement that was entered into between Bellaterra and Southside when they obtained this agreed judgment in June 14th of 2023. And they knew at that point that Tusker Capital had already foreclosed on the property. And so there was nothing, and this gets to another issue that we haven't had time to address, but is addressed in the brief. At the time that they agreed to the constructive trust on the property had already been foreclosed. And so there was nothing for Bellaterra to, quote, give a constructive trust, which another thing is, we argue in the brief,
But
is
that's a
you
separate
can't-
issue, though. Your client had notice of the lis pendens and chose not to intervene in the original action and chose instead to file its own lawsuit.
It chose not to intervene, Your Honor, because it did not believe the lis pendens to be valid. It saw no reason to do it because Bellaterra was seeking a suit for breach of contract and seeking specific performance.
But given that there was a lis pendens, that you would have to then get declared void, because the status quo was it existed until you had somebody come say it's void ab initio, is it your position that you otherwise complied with the statute as to how to invalidate, or do you think the statute just only binds other people, or help us understand that?
I would argue, Your Honor, that the statute is provides a procedure to eliminate or to invalidate a lis pendens. It is not the only method for doing so. And as we've touched on, because the lis pendens is void, because it does not rely on this direct interest, we are free to attack it in this way. Was the motion to expunge a lis pendens an option? Absolutely. But it is not the sole method in order to accomplish this relief.
And your best authority for that is what?
That
Just
void
first
judgments,
principles, or do you have cases on that?
I do not have a specific case on it.
Okay. No case going the other way, we don't know.
That's correct.
Okay, and I know time is up, but just very quickly, in a nutshell, if we were to agree with you, both that the lis pendens was void and that we could reach that in this case, what happens? They have a judgment, and I know you have a lot of other arguments in your brief. Can you help us just very quickly understand? I know you're saying that issue one decides the case, but what does that mean? I mean, we would have to write an opinion. What would we say? We render on what? What would we say about the other issues, about the constructive trust? If we only address issue one.
If you only address issue one, then we render, because again, the lis pendens is invalid, and that establishes the superiority of my client's interest. The original suit was the dispute about the superiority of the interests. And if the lis pendens is invalidated, that is what arguably gives effect to the binding nature of the other judgment. You know, again, as the court has touched on, yes, this other judgment stands out there, but there's no way for them to enforce that judgment. And if there is no lis pendens to bind the other judgment to my client, then it has no impact on it.
Then you're not aggrieved, and then there's, rather than you winning on the other issues, they should probably just go unreached or kicked back. You could probably live with that.
Yes.
Good?
I wouldn't put it that way.
Thank you.
I mean, you're right
These
about
are
these-
complicated questions, and we really appreciate, I think we're all collectively trying to figure these things out to make sure that we follow the law, apply it, and understand the issues. So thank you for helping us and guiding us through difficult questions.
Can you bring us something simple next time?
And as Justice Rivas-Molloy said, your both
excellent.
briefing was excellent,
Really
really excellent, and this argument was very, very helpful, so thank you.
Thank you very much, Your Honors.
With that, this case is now submitted, and we are now adjourned. Thank you.